Welcome to the L&M Medilaw podcast. Craig's Case Checker is created to keep you up to speed with the law of medical negligence, whether you're a solicitor, student, or curious observer.
And so what I'm wanting to primarily explore in this podcast today is, firstly, I'll outline the facts of SD just so that you have a bit of context about what was going on. And I'll give a brief outline of what Lady Wise decided in relation to the breaches of duty. And then from there, we'll kind of go into the heart of this topic, how Can versus Meadows was decided by the Supreme Court and how, in turn, Lady Smith applied, if at all, it to this case in SD versus Grampian Health Board.
Head to our website, lndmmedilaw.com, for more information.
Hello everyone, I am Craig Christie. I'm one of the solicitors with L&M Medilaw, and today is hopefully the first of many updates for medical negligence practitioners. And so what I hope to do in this series is to really kind of keep you practitioners up to date on all things medical negligence, and that's whether it's an actual medical negligence decision coming out of the court or any procedural matters from, say, the personal injury courts, which could apply also to medical negligence. And I know myself, and I'm sure many of my peers would agree, that trying to keep up to date with the case law as it comes out can be quite a daunting task when you're particularly busy. So I'm hopeful that this series in moving forward will be of some assistance to you all. And so starting at that point, what I would like to discuss today is the case of SD versus Grampian Health Board, which only just came out just last Thursday, which was the 8th of September 2022, in case you're watching this in 3 years' time. So what I'm wanting to discuss about this case today in particular is quite an interesting point which the defenders had tried to make in their submissions at the end of it. Many of you may be aware of the UK Supreme Court decision of Can versus Meadows, and that kind of looked into the scope of duty and the so-called SAMCO counterfactual. And the defenders tried to apply that to a clinical negligence case here relating to treatment or the omission of it. And so what I'm wanting to primarily explore in this recording podcast today is, firstly, I'll outline the facts of SD just so that you have a bit of context about what was going on. And I'll give a brief outline of what Lady Wise decided in relation to the breaches of duty, although I won't go into much detail about that. And then from there, we'll kind of go into the heart of this topic, and how Can versus Meadows was decided by the Supreme Court and how, in turn, Lady Smith applied, if at all, it to this case in SD versus Grampian Health Board. So on that note, I shall commence by outlining the particular facts of SD. I mean, in summary, it was on the 24th of August 2008 that the pursuer, SD, gave birth to her son, LD, at Aberdeen Maternity Hospital. Unfortunately, LD suffered severe acute asphyxia as a result of the compression of the umbilical cord shortly before birth and consequential quadriplegic dyskinetic cerebral palsy, leaving him severely disabled. So just to clarify, what we mean by compression of the umbilical cord was essentially the cord wrapped around LD's neck as he was being born, hence cutting off oxygen to his brain, unfortunately. So the pursuer sought damages for the loss, injury, and damage suffered by her son, which she avers was caused by the negligence on the part of certain midwives at the so-called Westburn ward at Aberdeen Maternity Hospital, and some unnamed doctors with oversight of the decision-making on Westburn ward during ward rounds, and also of a Dr. Sripada, and please forgive me if I've completely mispronounced that name. She was the obstetric registrar who was on duty that night. And she was the one who took the decision about not to perform a cesarean section shortly before LD was born. And that was a critical point in terms of both breach of duty and causation. So to elaborate further on the facts, so it was on the 21st of August 2008 that the pursuer was admitted to the Aberdeen maternity ward. And by this point, the pursuer was actually 13 days beyond her estimated delivery date. So she was taken in, and upon vaginal examination, the so-called Bishop score was 5, and the pursuer's cervix hadn't dilated very much, if I remember rightly. In any event, she was provided a drug known as Prostin, which was essentially designed to induce labor, to hurry it along. And so it was later that evening that a decision was taken not to administer a second dose of Prostin because the pursuer was contracting 4 times in 10 minutes. So it looked from their perspective, it looked as though she was progressing. So the plan was to examine her in the morning and just take it from there. So on the morning of the 22nd of August, a CTG was commenced at 8 a.m. And after 45 minutes, another vaginal examination was performed. The Bishop score this time was 6, and cervical dilation was at 1 centimeter. One of the midwives decided to do a membrane sweep instead of giving further Prostin. Likewise, she hadn't sought medical review at this point. And so the pursuer's contractions subsided by about 12:30 that day. And from there, the CTG was restarted at, 4:30 in the afternoon. And this ran for about an hour. Again, no further Prostin was administered. There's a note at 5 to 8 in the evening, which made it plain that there was contractions on palpation of 2 every 10 minutes, but still there was no progress in terms of dilation. So again, no medical review was sought at this point, and nor was Prostin administered. At about midnight on the 23rd of August, the midwives noted that the pursuer was having strong uterine contractions of 3 every 10 minutes. The pursuer had also spoke of a feeling of something trickling down her inner leg. So as a result, the midwives started to monitor this. Later on, they noted that her Bishop score had increased to 7, and the trickling was noted to possibly be meconium staining. Again, at this point, despite that, no medical review was sought. Another midwife noted the discharge on the pursuer's sanitary pad, recording that it may have been meconium or old blood. Again, no review was sought at this point. On further examination at 2:30 in the afternoon on 23rd of August, this showed an increased Bishop score of 8 with cervical dilation unchanged. It was at this point that a decision was made to administer a second dose of Prostin. Again, no review was sought. Paracetamol was then administered at 3:05 in the afternoon, and another CTG was commenced about 40 minutes later at 3:45. Again, no review. It was then about 10:35 p.m. that midwife noted that there were early decelerations on the CTG, but which these responded well to a change in maternal position. And about 45 minutes later, a vaginal examination was performed. It was noted that the Bishop score had gone back down to 7, and again, no progress with dilation. So at this point, a medical review was called for, and Dr. Sripada came and saw the pursuer and decided she needs to go to the labor ward. So she was transferred to the labor ward at about midnight on the 24th of August. The CTG was recommenced and ran throughout the time that she was on the labor ward. An amniotomy was then performed with difficulty, and at about 2:10 in the morning, grade 2 meconium was noted on the sanitary pad. Then at about 3:45 in the morning, one of the midwives noted the CTG to be suspicious. So she called on Dr. Sripada, who reviewed the CTG at 4:10. She did a vaginal examination and found that the pursuer's cervix was fully effaced, 3 centimeters dilated, and was well applied to the presenting part. Quite technical speak, but it kind of indicated that things were progressing. Dr. Sripada then considered whether or not a cesarean section was appropriate in the circumstances. Having interpreted the CTG, she decided no, one was not required. But she decided just to continue monitoring the CTG and to review in half an hour's time. However, at about 4:36, the fetal heart rate dropped suddenly, and the midwives had noted a fetal bradycardia. About 10 minutes later, Dr. Sripada was then called and attended at about 04:53. Immediate action was taken to deliver the baby, which occurred at about 5:15 in the morning. But as I say, unfortunately, LD, the baby who was born, suffered brain damage due to the cord compression. And so, like I say, I'm not going to go into much detail about the reasons why Lady Wise reached her decisions on breach of duty, but it will suffice to say that she found there was no breach of duty at all in relation to the care which was provided to the pursuer, and also in ensuring LD was born unharmed. But to maybe summarize the position, with regard to the midwifery care, the overriding contention by the pursuer was that the induction of her labour and subsequent delivery was delayed unreasonably. So you may remember that there was a lot of talk about Prostin not being administered again after the first one for quite a while, and also generally no medical review sought until fairly late in the day. And as a consequence, the decision to transfer the pursuer to the labour ward was delayed as well. Lady Wise had found that there was no breaches of duty in respect to any of that. She considered that the midwives could have progressed the pursuer's labour quicker, but overall it didn't amount to a breach of duty. With regard to the obstetric case, the pursuers were essentially arguing that Dr. Sripada was negligent in failing to organize a cesarean section when she was reviewing the CTG at 4:10 in the morning on 24th of August. So, according to the pursuer, the CTG was showing something which was pathological, that something very bad was going wrong, and that therefore indicated the need for a cesarean section. The defenders, on the other hand, led evidence to say that the trace was actually quite normal and was, at worst, suspicious. And based on the expert evidence which Lady Wise heard, she considered that this was just one of those situations where she could not really say for certain whether the opinions of each expert was erroneous, or she couldn't actually decide which position she preferred. So it was one of these Honish situations, which I hope you're all aware of. And it was agreed between the experts for both parties that reasonable obstetricians could easily differ on the interpretation of the CTG at that time. So overall, Lady Wise had to find that there were two different but equally supportable interpretations of the critical CTG trace. Therefore, it was reasonable to classify the trace as suspicious but not pathological, and therefore Dr. Sripada could not be said to have acted negligently by opting to continue monitoring and not arrange a cesarean section. The final case which the pursuers had pursued was in relation to the decision-making on ward rounds. So essentially, they contended that if evidence of the ward rounds, what was going on in them, what was done, was accepted, then their position was that the medical decisions being made on those rounds was negligent. And given their overriding contention that there was a failure to administer Prostin earlier, seek medical review, and then transfer the pursuer to the labour ward, the pursuers felt that it was strongly implied that the advice of the doctors on the ward rounds fell below the standards in their duty of care. So in other words, it's likely that the pursuer's condition and her progression in labour was being discussed on ward rounds by the doctors, and so in their failing to instruct or arrange more Prostin to be provided or for further review and transfer to labour ward, they fell below the standard of care owed to the pursuer. Lady Wise accepted the evidence on the ward rounds, but considered that nothing there showed there to be negligence. To her mind, it was clear that the pursuer was discussed by the doctors. No one was unhappy with the decisions that they were making, or nor did any of them suggest an alternative intervention or treatment. So on that basis, Lady Wise felt that there was no breach of duty in relation to that case as well. So that's really a summary of the breaches, maybe slightly longer than I would have planned. But now we move on to the core of this recording podcast, which speaks about the scope of duty and causation in the case. Now, obviously, it's not particularly important from in terms of the final decision reached by Lady Wise, because in the end, she found no breach. So therefore, she doesn't have to consider causation, but she did anyway. And in doing so, she had to consider a fairly novel argument by the defenders. They argued that essentially the Supreme Court case of Khan versus Meadows applies to the situation, to the criticisms of the midwives. Now, I think before I really get into the nitty-gritty of what exactly the defenders were arguing, it would probably help if I give a bit of context and explained what the decision of Khan versus Meadows actually was. So moving on to looking into that case in a bit more depth. In Khan versus Meadows, the appellant, Ms. Meadows, attended her GP practice and consulted with Dr. Khan specifically to find out if she had the hemophilia gene and what impact that may have on her if she were to become pregnant. Dr. Khan had instructed the inappropriate tests to actually determine whether she was a carrier of the gene. This obviously led to a negative result, and so Ms. Meadows was advised that you don't have the gene, you can crack on and get pregnant and you'll be fine. And so as a result of that advice, Ms. Meadows a few years later became pregnant, but as it turned out, she did have the hemophilia gene, and she gave birth to a child with hemophilia and autism, which is the kind of crucial part in this. So she was arguing that if she knew she had hemophilia, then she would never have had the pregnancy, and therefore would not have had to incur the costs of raising a son with both hemophilia and autism. So she was suing for the cost of raising a child with both of these conditions. And so what the Supreme Court was asked to look into was essentially whether the damages for raising a child with autism, something which was not specifically predicted, falls within the scope of duty of care of Dr. Khan in this situation. And the respondents for Dr. Khan, in other words, was arguing that the so-called SAMCO principle applied in this situation. So before I go into the nitty-gritty, it'd be helpful to kind of outline what exactly the court explored as a whole in that decision, because essentially what this case was looking at was determining liability in cases where damages are being sought for negligence. And ordinarily, as many of you will know, it's usually the case of duty of care breach and damages. Fairly straightforward, but in this case, the Supreme Court outlined that there was actually 6 elements which one had to consider when determining liability in these cases. And these 6 questions are as follows. Question 1, is the harm, which is the subject matter of the claim, actionable in negligence? This is known as the actionability question. 2, what are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? That's known as the scope of duty question. Number 3, did the defendant breach his or her duty by his or her act or omission? The breach question. Number 4, is the loss for which the claimant seeks damages the consequence of the defendant's act or omission? That's the factual causation question. Number 5, is there a sufficient nexus between a particular element of the harm for which the claimant seeks damages and the subject matter of the defendant's duty of care as analysed in stage 2 above? And this is known as the duty nexus question. Lastly, number 6, is a particular element of the harm for which the claimant seeks damages irrecoverable because it is too remote or because there is a different effective cause? For instance, novus actus interveniens, in relation to it, or because the claimant has mitigated his or her loss or has failed to avoid loss, which he or she could reasonably have been expected to avoid. And this is known as the legal responsibility question. The court explores all of these questions in some depth as to what the basis of them is, but I'm not going to do that, lucky for you. I'm going to focus on probably the more 2 important questions in this case, which was in relation to question 2, the scope of duty question, and question 5, the duty nexus question. So in relation to scope of duty, the court found, based on precedents, of course, that it was an established principle that the law addresses the nature of the extent of a duty of care in these cases. They quoted Lord Denning in Roe versus Minister of Health as saying, is the consequence fairly to be regarded as within the risk created by the negligence? If so, the negligent person is liable for it, but otherwise not. And as we all know from cases in relation to pure economic loss and psychiatric injury, the law considers the nature of the damage when assessing the scope of duty of care. So, for instance, pure economic loss, which kind of comes into play later in this case, for valuers' cases, for instance, the scope of duty of care is limited depending on what exactly the valuer was doing on behalf of the claimant. Was it just a bit of advice, or were they directing them on how to make a decision in relation to their finances? Likewise, with psychiatric injury, you have to establish a lot of little interactions and relationships here and there before it really applies. The court then goes on to look at the so-called Samco principle, which was a decision by the House of Lords in 1997. And this is described as where a defendant is not liable in damages in respect of losses of a kind which fall outside the scope of their duty of care. The court says that this is more of a counterfactual question and is in fact more like the question number 5, which again I'll be exploring a little later. They made it quite clear, though, that this duty nexus question, or the Samco counterfactual, is used in some but not all circumstances. So it's not the case in addressing each of the 6 questions that you have to use question 5 or answer question 5 or even ask it. If the duty of care and the scope of it is very clear, then there's no need to look into whether or not any damages suffered fall out with the scope of that duty. So, I mean, quite often the whole notion of the Samco counterfactual arises when the quantification of damages is a bit more complicated. As I say, if it looks as though the damages fall out with the scope of duty, then that's where Samco actually kind of comes in. Lord Sumption summarised the position of all of this in the Hughes-Holland decision, stating that the two fundamental features in the reasoning in Samco were, one, where the contribution of the defendant is to supply material which the client will take into account in making his own decision on the basis of a broader assessment of the risks, the defendant has no legal responsibility for his decision. And two, the scope of duty principle has nothing to do with the causation of loss, as that expression is usually understood in the law. So with respect to the first feature, Lord Hoffman in Samco drew a distinction between the provision of advice and, on the other hand, information, but said that these weren't mutually exclusive categories. Essentially, what the court's going to be doing is to try and identify the purpose for which that advice or information was given to the claimant or pursuer. Ultimately, it depends on the extent to which the provider of the information or advice has contributed to the claimant's overall decision-making process. And, having said that, you may see where this comes into play in Can versus Meadows. So where the advisor is not guiding the whole decision-making process, the duty nexus question becomes important, because the court must then separate out from the loss which the claimant is seeking damages for from that which the negligent advice is attributable. So that's scope of duty, even though it kind of looks at duty nexus question quite a bit. But moving on to that, as I say, it can be answered fairly straightforwardly, probably in most cases, that the defendant or defender has unquestionably a duty of care to prevent harm to the claimant, or protect or reduce the risk of it at the very least. And as I say, there will be times that the harm suffered will actually fall outside the scope of the duty of care. It also applies where the quantification of damages brings that particular issue up. So when that happens, the duty nexus question comes into play. And in Samco, Lord Hoffman stated the matter thus: "It is that a person under a duty to take reasonable care to provide information on which someone else will decide upon a course of action is, if negligent, not generally regarded as responsible for all the consequences of that course of action. He is responsible only for the consequences of the information being wrong. A duty of care which imposes upon the informant responsibility for losses which have occurred, even if the information which he gave had been correct, is not, in my view, fair and reasonable as between the parties. The principle thus stated distinguishes between a duty to provide information for the purposes of enabling someone else to decide upon a course of action and a duty to advise someone as to what course of action should be taken. If the duty is to advise whether or not a course of action should be taken, the advisor must take reasonable care to consider all the potential consequences of that course of action. If he is negligent, he will therefore be responsible for all the foreseeable loss, which is a consequence of that course of action having been taken. If his duty is only to supply information, he must take reasonable care to ensure that the information is correct, and if he is negligent, will be responsible for all the foreseeable consequences of the information being wrong." So that really sums up in a nutshell what the Samco counterfactual is all about. So really the question that you've got to be asking if that problem arises is, what would the claimant's loss have been if the information which the defendant in fact gave had been correct? So the question is not whether the claimant would have acted differently if the advice was correct. Rather, the counterfactual assumes that the claimant would behave as he did in fact behave, and asks whether, if the advice had been correct, the claimant's actions would have resulted in the same loss. So from asking that question, the court can then ascertain the loss attributable to the information being wrong. In some circumstances, it is appropriate to use this counterfactual. In others, it's not, because, as I said before, the scope of duty question may identify a fair allocation of risk between the parties without the counterfactual being used. Now, it was argued by Ms. Meadows in this case that the Samco principle, primarily arising from valuers' negligence cases, shouldn't actually apply to clinical negligence. But the UK Supreme Court held that there was actually no principled basis for excluding clinical negligence from the scope of duty principle, or even the counterfactual question, or duty nexus, I should say. As Lord Sumption had noted in Hughes Holland, the scope of duty principle is a general principle in law, in the law of damages. So therefore you can't really argue that it just simply doesn't apply to clinical negligence. But the court does acknowledge that in many, and probably a high majority of cases of clinical negligence, the application of the scope of duty principle results in the conclusion that the type of loss or element of a claimant's loss is within the scope of duty of the defender, and without actually having to apply SAMCO. For example, the court, quite conveniently, for the purposes of SD, made the following points. The negligent care of a mother in the final stages of pregnancy can sadly have the result of the birth of a baby with brain damage, and the defendant is normally liable to pay compensation for both the injury and the consequential additional cost for the disabled child. In the cases of Parkinson and Groom, the object of the service being undertaken was to prevent the birth of any child, as in each case the mother did not want to have any more children. In Parkinson, the service undertaken was to prevent a pregnancy, while in Groom, the task which should have been performed was to make sure that the mother was not pregnant, notwithstanding her recent sterilization. In both cases, the added economic costs of caring for a disabled child, whatever his or her disability, were within the scope of the defendant's liability because of the nature of the service which the defendant had undertaken. In none of those cases did the SAMCO counterfactual have a role to play, but it is necessary in every case to consider the nature of the service which the medical practitioner is providing in order to determine what are the risks which the law imposes a duty on the medical practitioner to exercise reasonable care to avoid. That is the scope of duty question. So in applying these principles to the facts in Can v. Meadows, they did acknowledge that in terms of factual causation, but for Dr. Can's negligence in advising Miss Meadows that she did not have the haemophilia gene, her son would not have been born, and hence would not have had autism as well. But to their mind, the answer to the factual causation question didn't provide the full answer on scope of duty of care. So the foreseeability of the boy being born with autism and haemophilia were relevant considerations. It was acknowledged that autism was a foreseeability of pregnancy and birth, but this didn't determine the scope of duty question. And as they said, the scope of duty principle is dependent on, principally, the nature of the service which the defendant was undertaken to provide. So the question was, what is the risk which the service which the defendant undertook was intended to address? So in this case, essentially, Ms. Meadows had come in to see Dr. Can specifically to ask about the haemophilia gene and to be tested for it. And so looking at the nature of the service which Dr. Can was providing, i.e. to advise on haemophilia, they held that the scope of duty for Dr. Can's actions was purely that, to advise on the haemophilia gene and whether or not Ms. Meadows had it. As a result, if one applies the counterfactual question, would the outcome have been the same if Dr. Can's advice was actually correct, that the mother did not have haemophilia? And the answer to that is yes, he'd have been born with autism, albeit without haemophilia. So having come to that conclusion, the court said that the Dr. Can was only liable for any costs related to haemophilia and not autism. A lot of it makes sense, but it's an interesting decision, and certainly helps to clarify how we all should be approaching the question of negligence and whether or not a defender is liable. But as I say, this was actually used in SD versus Grampian Health Board by the defenders in their submissions. And so I'll now go back to that and see exactly what they had said and argued. So keeping all of these principles in mind, and I hope that you remember them, but the defenders argued that even if it could be proven that the child in SD would have been born uninjured, there was a scope of duty issue which was overlooked as distinct from the usual but-for test. So the defenders queried why any midwife who saw the patient on the 22nd and the 23rd of August in the induction ward for the purposes of managing that induction would be responsible for the injuries that LD subsequently suffered in the following day in the labour ward caused by something that could not be predicted, even minutes before 42 past 4 in the morning. So they questioned whether the breaches of duty of the midwives, if there were any, could have resulted in liability for all injuries which LD had suffered prior to birth, regardless of the cause. So essentially, they're trying to argue that the counterfactual comes into play here because, to their mind, the actual damage caused was unrelated to the role and scope of duty of the midwives. So, to their mind, given that the midwives had no continuing involvement with the pursuer in the labour ward, their obligations ceased on the pursuer's transfer there. It was not part of their service that they provide to secure the delivery of the baby, and they cannot therefore be regarded as having assumed responsibility for that. The care for the delivery was by different midwives and Dr. Sripada. So they concluded that a midwife had undertaken a particular restricted role in the delivery of LD, and the risk of an outcome unrelated to that role will not, as a general rule, fall within the scope of their duty of care. So they do try to apply Kahn and Meadows quite directly to this situation. The pursuers contended that in the record, the defender had admitted that had LD been born by 50 minutes past 4 that morning, he would probably not have suffered any brain damage. As a consequence, the pursuer's expert did not give evidence on the nature of the relationship between the midwife's breaches and the ultimate outcome. And this is quite important, as I'll highlight. Nonetheless, the pursuers contended that each witness accepted that there was an increased risk of cord compression where there is a prolonged pregnancy. So these alleged breaches of duty happened against that background. To the pursuer's mind, Kahn v. Meadows was not in point because there was unchallenged evidence about the link between prolonged pregnancy, cord compression, and stillbirth. They felt that it was quite a novel argument to try and distinguish induction of labour from delivery. To their mind, the duty of care incumbent on everyone involved in this was to avoid the risk of injury or stillbirth to the child. So this meant that their duties extended up to that. It wasn't restricted to simply inducing labour, and that was that. Having considered all of that, Lady Wise nonetheless concluded that the harm to LD was actually too remote from his time on the induction ward for there to be a sufficient nexus between any breaches on the part of the midwives and the outcome. Now, she accepted up to a point that induction and delivery are linked to the extent that they cannot be deemed as two distinct services. So that's one part of the Kahn-Meadows argument by the defenders kind of knocked out of the park there. She said that there was a general duty on the midwives to take account of risk factors and not to prolong the induction beyond acceptable timeframes without good reason. However, she goes on to state that where the case essentially failed was not so much in the application of the counterfactual question, but more on causation. She noted that the pursuers essentially failed to lead any evidence to demonstrate that the breaches of duty of the midwives on the induction ward had actually affected the ultimate outcome. She said there was no evidence of what would have happened had the pursuer been transferred to the labour ward earlier, nor was there any evidence of the effect which an earlier dose of Prostin would have had on labour. There was no evidence of how long the pursuer would have been on the labour ward without further intervention, assuming that continuous CTG monitoring gave no cause for alarm. To her mind, the accepted risks of prolonged pregnancy were just very, very general. And so as a result, she couldn't possibly say that there was a link between the prolonged pregnancy in the induction ward and the ultimate outcome. And this is notwithstanding the pursuer's contention that it was admitted on record that birth before 10 to 5 would have resulted in the child being born uninjured. In the end, they didn't prove what would have happened had she been transferred to labour ward earlier. And I'll explain what questions arise from that. But in terms of the obstetric case, Lady Wise was quite clear that no scope of duty issues arise from that. There was a very clear direct link between the alleged breaches of Dr. Sripada and the outcome. So some may look at that decision and think, has Lady Wise actually applied Canon Meadows to the circumstances here? From looking at it, I think she really hasn't in the end. She, as I said before, she essentially rejects the argument by the defenders that there were two distinct services, and so the scope of duty of the induction midwives was different to that of the delivery midwives. I think, while she doesn't express it, I think, at least to my mind, I would agree with the pursuer's contention that the overriding duty of care owed by the midwives from the start of induction through to delivery is to ensure that the child is born unharmed. I fail to see how you could really divide it into two distinct services with two distinct